Hello everyone, I'm Dawn. Thank you so much for visiting with me today. If you haven't already, please consider subscribing to my channel, The Cutting Board. We do all kinds of content here. We do true crime, DIY, SFX makeup, hauls, vlogs, food content, and most importantly, at least to me, Disney content. I have a lot of interests and I want to share them with you. So if any of that interests you, please join me. So there have been some new filings regarding Stephen Stearns by his defense team. And look, I'm not here to beat up his attorneys. They are supposed to work in the best interest of their client, and they can get into big trouble if they don't do that. And, if a judge decides that they're not doing the best job possible, they can nail them. So I'm not going to blame an attorney for doing their job. It's very likely they do this for all their clients in similar cases. It's expected. So there have been 70 plus filings since January 8th by the defense as well as the prosecution. Now, we will not be going over all of the filings because that'll be a long video. But if you go to courts.osceolaclerk.com, you can look the case up and read all of the filings yourself. And I will provide that link in the description of the video if I remember. If I don't remember, someone remind me in the comments. Regarding the death penalty, there is a filing of motion that the defendant, Stephen Stearns, by and through his undersigned attorney, moved the court for an order declaring the Florida statute unconstitutional based on violations of the 5th, 8th, and 14th Amendments to the Constitution. I'm no attorney, but I think that this motion will probably be denied. And again, anytime that there's a death penalty case, it's probably common to file this motion. So in Florida, homicide can be punishable by death if it involves just one of the following aggravating factors. And there are many, so I'm only going to bring up the ones that I feel could apply to Stephen Stearns. First of all, it was committed by a person previously convicted of a felony, or the defendant was previously convicted of another capital felony involving the use or threat of violence. I think that this one, though it may not apply right at this second, I think by September, by the time the homicide trial takes place, it will apply because he would have already had his child SA trial and likely found guilty. So depending on how you spin it, those crimes could be considered violent. I definitely consider them violent. I think that those are violent crimes. It was committed while the defendant was engaged or was an accomplice in the commission of another felony, such as aggravated CA or child SA. It was committed for the purpose of avoiding arrest or effect an escape from custody. I think that one of the reasons, or one of the possible reasons, he unalived Madeline was to avoid getting caught for what he'd been doing to her for years. But I mean, you would have to be an idiot to believe that you weren't going to get caught. But I don't think that he's exactly the brightest bulb in the box. You know what I mean? If the crime was committed for financial gain, the reason I include this is it's a far off reason. It's out there, but it's a theory I've heard from a lot of people that maybe someone, it's still possible, maybe someone offered him a good chunk of change for a snuff film. Somebody, could have done that. It's entirely possible. I don't think that was the case, but it could be. And if that was the case, that opens a whole new can of worms. I don't think that was the case. I think that he was so convinced that he was in love with this little girl. But, even though that's not how you love somebody, but in his warped mind, maybe he thinks it is. I don't think he would have done that to Madeline for a snuff film. Another factor, it was especially heinous, atrocious, or cruel. I don't think anybody is going to argue with that one. It was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And remember, premeditation can just take 1 second before the act. The victim was particularly vulnerable because the defendant stood in position of familial or custodial authority over the victim, sort of like a stepdad. It was committed by a person currently or formerly designated as a sexual predator. Now, again, that's not something that is the case now, but once he's convicted of the sex crimes, it will apply. And that's one of the reasons I feel they're holding the trial, the CSA separately, like the sex crimes trial separately from homicide, so they can have that conviction on the books. Yeah, so, by September. So he'll have that designation by then, because there's just no way that he's going to get out of those sex crimes. There's just no way. I mean, crazy things have happened in courts in Florida. For example, Casey Anthony. So, I don't know. Hopefully, and I feel confident that they've got him on this. Now, the prosecution is not seeking the death penalty for the sex crimes, although they can, because Governor Ron DeSantis did sign a bill that allows the death penalty for defendants convicted of capital sex crimes against children under the age of 12. But it would be challenged in court as unconstitutional for several reasons if it ever comes up. But it won't, because they're not seeking the death penalty on the sex crimes. The first attempted use of that law where they seek the death penalty for the sex crimes was in the case of Joseph Giampa, who pled guilty rather than risk the possibility of execution. So we never found out if it got argued unconstitutional or not. I'm sure it would have been argued, though. Another motion in Lamine to require state to proffer any and all victim impact evidence. Basically, the defendant, by the filing of that motion, maintains any and all objections to the use of victim impact evidence in its entirety, because victim impact evidence, particularly in this kind of case where a child is involved and it's just so vicious, is normally extremely emotional and has a high probability of unduly, unfairly, and unconstitutionally inflaming the jury, therefore making it impossible for the defendant to get a fair sentence in that sentencing phase of his trial, free of bias and prejudice. But whatever. I challenge them to find 12 jurors that don't have a personal problem with child predators. I guess go find 12 perverts off the internet so he'll have a jury of his peers, because those are his peers. There is also a motion filed to declare sections 921.141 and or 9211416H of Florida statutes jury instructions unconstitutional, in the part where this is what they're using to seek the death penalty, especially heinous, atrocious, or cruel factor. So Stephen Stearns is charged with committing first-degree homicide. The state has filed notice of its intention to seek the death penalty if there is a conviction on the capital unalivened charge. And in its notice, the state intends to rely on the especially heinous, atrocious, or cruel aggravating circumstance set out in Florida statutes, and its efforts to seek the death penalty for Stearns. The motion claims that the especially heinous, atrocious, or cruel aggravating factor is unconstitutionally vague and overbroad and is not capable of a constitutionally adequate narrow in construction and has actually been applied in an arbitrary and inconsistent manner. If they want that removed, I'm sure that the prosecution can come up with another reason to seek the death penalty, another aggravating factor, because, I read them to you. There are plenty of aggravating factors that could apply to Stearns. I mean, if anyone thinks that the unaliving of a child isn't heinous, atrocious, or cruel on its own, I have real questions about that person's morals. I don't think it's brought up at all, but I guess that's why I'm not a lawyer, They also want to exclude all victim impact evidence. They want to exclude evidence or argument designed to create sympathy for the victim or vilify Mr. Stearns. Oh, he doesn't want to be vilified. It's actually really easy to avoid being vilified, Mr. Stearns. Well, maybe he shouldn't have essayed a little girl for a minimum of 4 years, probably longer, and then unalive her. People tend to vilify child predators and killers. I mean, call me crazy. It's just a thing we as human beings do. But there are several other motions filed. A lot of them seem to be redundant, but probably necessary as far as case filings go. Again, these are all in regards to the homicide trial in September, not the trial coming up in February, or that is currently scheduled for February. It'll probably be changed. Both trial dates will probably be changed. But again, the child SA trial is currently scheduled for February 24th currently, and the pretrial is February 12th. And I don't know that it will be televised. I don't think it will due to the nature of it. Because, he's charged with 60 counts of pretty disgusting things. And it may not be televised. They have also put in a motion to continue on February 6th. So the date may be moved because that motion was just put in. So that's possible it'll be moved. And it probably will be because they claim additional time is needed to prepare the case for trial. Now, I know I've only gone over a couple of the motions, but again, you can go to court.osceolaclerk.com and search for Stephen Stearns and go into his case, and you could look up information about the trial in February and the homicide trial. So go gather all the information you can, if that's of interest to you. I may do a live about these filings, but, do a deeper dive into it, but I'm not sure. I'm just very uncomfortable doing lives. I hate doing lives. I hate them. And it's because I'm not used to them. I need some moderators. I have a couple, but I haven't seen some of them around in a while, so I don't know if anyone will be around for it, but let me know if you'd like to be a moderator, and maybe one day I'll do a live. I don't know that I would get any viewers because I've tried lives before and nobody comes in, so I'll just see. I'll see what happens. But I think that's all for this video. I'm going to try and get all these documents together for y'all and place somewhere. Maybe I'll make a website or something. I don't know. I'm on all the cases I do. Maybe I'll create a website or something. I don't know. I'm just working on figuring all that stuff out. But that's all for now. I'm burpy. I'm sorry. But thank you so much for watching, and I will talk to everyone later. Bye.